On October 30th, 2024, Fannin County deputies received a report about a young boy seen walking alone near the intersection of Mineral Bluff Highway and Georgia 60. A bystander noticed the 10-year-old entering a Dollar General store. When she asked if he was okay, he responded affirmatively and declined any help, mentioning his mother's name Brittany Patterson and that she worked at the post office. He then continued on toward a nearby fire station. Deputies located the child soon after, placed him in a patrol vehicle, and contacted his mother. Brittany Patterson, a former educator with a master's degree, lives on a 16-acre property with her children and her father, while her husband works out of state. She was stunned when she received a call from a female deputy informing her that her son had been found downtown. Brittany explained that she had just left to take another child to a medical appointment, and her father, who is always at home, was supervising. She didn't express alarm, noting that her son was mature, familiar with the area, and had made the walk before without incident. However, the sheriff's office viewed the situation differently, raising concerns about potential risks, such as abduction or being hit by a car. The deputy drove the boy home and left him with his grandfather. Brittany disciplined her son and believed the situation was resolved. It wasn't. Later that same evening, around 6:30 p.m., deputies returned to the Patterson home. A conversation ensued regarding adult supervision, and Brittany again confirmed that her father was the only adult present. She was then abruptly told to turn around. She was under arrest. When she asked why, the deputy cited the earlier incident and said she was being charged with reckless endangerment. Brittany was stunned. She questioned how letting her son walk could be considered reckless. She argued that allowing a 10-year-old to walk to a familiar location isn't inherently dangerous or illegal. However, the deputy maintained that at that age, it was against the law, referencing a warrant. Brittany asked for someone to stay with her children since no other adult was available. She was taken into custody and released a few days later after posting a $500 bond. Child Protective Services then introduced a safety plan requiring her to assign a guardian anytime she left the house and to install a GPS tracking app on her son's phone. Brittany refused, arguing that the plan was both invasive and unnecessary. In a media appearance, Brittany explained that she does not parent from a place of fear. She emphasized that she assesses risk based on data, not sensationalism, and believes the odds of something like a child abduction are extremely low. According to her, raising independent children involves accepting some level of risk and that micromanaging their movements does more harm than good. She underscored that her approach to parenting is a personal choice, not a crime. Her attorney, David Delegas, confirmed that law enforcement never offered a plea deal or alternative resolution. He said signing the CPS safety plan was portrayed as a possible solution, but that doing so would imply wrongdoing, which Brittany strongly refuted. He added that the GPS requirement was unrealistic and set her up for future violations, comparing it to a probation-like condition for a non-criminal situation. A court document dated February 7, 2025, revealed that the district attorney's office, after reviewing body cam footage and other evidence, chose to dismiss the reckless endangerment charge. However, Brittany Patterson still carries an arrest record, even though no crime was ultimately found to have occurred. What do you think? Should a parent face arrest for trusting a 10-year-old to walk to town alone, especially when nothing harmful happened? Was Brittany Patterson being irresponsible, or does this appear to be an excessive reaction by law enforcement? Share your thoughts below.